"Ma'am, this line is for attorneys only." The voice cuts through the marble lobby like a blade designed to sever confidence. Frank Millstone stands with his arms crossed, blocking the velvet rope that separates the attorney security lane from the general public queue that snakes 30 people deep. His uniform stretches tight across a chest built for intimidation, badge catching the overhead fluorescence. Behind him, 3 white attorneys pass through the metal detector unchallenged, briefcases sliding onto the conveyor belt with the ease of people who've never been asked to prove they belong. Simone Harper stops walking. Her navy suit is pressed sharp enough to cut paper, briefcase handle warm in her left hand. She doesn't shift her weight, doesn't adjust her grip. Just meets Frank's eyes with the kind of stillness that comes from practice. "I'm here for court business," she says. Frank's jaw tightens. "General public line is over there." He jerks his thumb toward the crowd pressing against the metal barriers, voices echoing off stone walls built to make people feel small. "Attorney Lane." Simone's voice carries no question mark. "Let me see your credentials." If you're already hooked by what's about to happen here, make sure you're subscribed, because this story is about to take a turn nobody saw coming. She reaches into her jacket pocket, produces an Illinois attorney registration card. Official laminate with holographic seal, her photo centered above bar number 6284719. Frank takes it, turning it over twice, holding it up to the light like he's examining a counterfeit bill. 40 seconds pass. A white man in his 60s, rumpled suit and coffee-stained tie, walks past them both into the attorney lane. No one asks him for identification. "This could be fake," Frank says. Behind Simone, the general queue shuffles forward. Someone coughs. A baby cries. The courthouse clock above the security checkpoint reads 8:47. Her hearing starts at 9. 13 minutes to get through security, reach the 5th floor, review her notes one final time. Judge Raymond Kemp hates late appearances, has dismissed motions for less. It has a holographic seal and QR code. Simone gestures toward the verification scanner on Frank's desk, black plastic rectangle with a glowing green light. "You can verify with the scanner." Frank sets the card down without scanning it, pulls out his radio instead. "Need supervisor at checkpoint 3. The static crackle fills the space between them. Simone checks her watch. 8:49, 11 minutes. Behind the checkpoint, she can see the bank of elevators that will take her to courtroom 5B, where her client waits. Marcus Wilson, 17 years old, facing 5 to 7 years on a felony theft charge built on evidence obtained during an illegal search. This motion hearing is everything. Win it, the case falls apart. Lose it, a teenager's life gets compressed into a cell barely bigger than a parking space. What kind of court business? Frank's voice pulls her back. Simone keeps her tone level, professional, the voice she uses when she knows someone is waiting for her to slip. The kind that starts in 10 minutes. A second security officer appears from the checkpoint supervisor's office. Vernon Blake, early 60s, 20 years of bureaucratic authority carved into the lines around his mouth. He approaches with reading glasses already in hand, prepared to scrutinize. "What's the issue, Frank?" "This woman claims she's an attorney." Card looks off. Vernon takes the registration card, examines it with the care of someone searching for any flaw that will justify what's already been decided. "Registration current?" "Renewed in December," Simone says. "You can verify the number online." Vernon's eyes flick from the card to her face and back. "We've had issues with counterfeit credentials. Standard procedure requires additional verification for unfamiliar individuals." Unfamiliar. The word lands with the weight of all its implications. Simone has been to this courthouse 47 times in the past 6 months, has passed through checkpoint 3 at least 30 of those visits. But Vernon uses unfamiliar like it's a policy term rather than a choice, like the 2 white women attorneys who just walked past chatting about their weekend plans are somehow more familiar despite neither one making eye contact with any security personnel. "I have case assignment documentation." Simone pulls papers from her briefcase. Court appearance notice stamped with the clerk's office seal. Case number 2024-CR-8847, People versus Marcus Wilson. Motion to suppress filed 10 days prior, date stamped and indexed. Courtroom assignment typed in, official courier font. Judge Kemp, courtroom 5B, 9 a.m. Vernon reviews the documents for 90 seconds that stretch like taffy. The clock ticks to 8:52, 8 minutes until her hearing. The elevator bank is visible through the checkpoint glass. Empty. Waiting. This looks in order. Vernon hands the papers back. But we'll need to confirm with the clerk's office. That's not standard procedure. Simone's voice doesn't rise, doesn't plead. States fact like reading weather data. I've shown valid credentials and case documentation. It is today. The checkpoint area has gone quiet. The attorneys who passed through unchallenged have disappeared into the elevator bank. The general queue still shuffles forward, but several people in line are watching now. Phones appear, recording angles unclear but intention obvious. Something is happening that doesn't happen to everyone. Simone pulls out her phone. I'm calling the presiding judge's chambers to report this delay. Frank's hand moves toward her. No phones allowed in the security area. Hand it over. She takes one step back, arms at her sides, phone held low and visible. I'm not through security yet. I'm still in the public corridor. You have no authority to confiscate my phone. Frank moves into her personal space, close enough that she can smell the coffee on his breath and see the individual broken capillaries in his bloodshot eyes. His hand hovers near his belt, not his weapon, but the zip-tie restraints that hang like a promise of what comes next for people who don't comply. The security checkpoint falls away. The marble lobby fades. Time compresses into this moment, this space between backing down and holding ground. Simone knows what happens to black women who assert their rights in spaces guarded by men like Frank. Knows it in her bones and her training and the careful protocols she's built for surviving encounters designed to make her small. She doesn't move, doesn't raise her voice, just holds Frank's gaze with the kind of steady that comes from knowing she's already documenting everything that matters. 8:57, 3 minutes until her hearing starts. 3 minutes until Judge Kemp calls for counsel and she's not there. 3 minutes until her client's case gets derailed by a man who decided she doesn't belong the moment he saw her face. Vernon murmurs into his radio, voice too low to hear clearly. Frank's hand drops from his belt, but his body stays positioned in her path, blocking any direct route to the metal detector. Behind them both, the queue has backed up. 12 people deep now, murmurs spreading through the line. Just let her through, someone calls out. Female voice, white accent. This is ridiculous. Ma'am, please don't interfere, Frank says without turning around. The Good Samaritan goes quiet. Simone notes her face anyway. 40-something white woman in a charcoal suit, probably an attorney, definitely someone who means well, but won't risk more than one sentence before preserving her own passage through systems that treat her differently. A woman in her late 40s emerges from the clerk's office near the checkpoint. Patricia Lamb, 17 years at the courthouse, survivor of every regime change and budget cut through the careful art of never making waves. She's black, like Simone, but her eyes don't meet anyone's as she approaches the computer terminal Frank has set up on the security desk. Let me check the roster, Patricia says. She types for 30 seconds. The keyboard clicks echo in the waiting silence. People in the general queue have given up pretending not to stare. More phones appear. Someone whispers, "Is that a lawyer?" to their neighbor. Simone Harper. Patricia reads from her screen. Bar number 6284719. Active status. Simone exhales a fraction of tension. This should end it. Clear verification from the official source. But, Patricia's voice drops. There's a notation here. What notation? Simone keeps her tone neutral despite the way her pulse picks up. Just says, verify credentials in person. Not sure what that means. There is no notation. Simone has checked her own attorney profile a dozen times for exactly this reason. Has screenshots on her phone from as recently as last week showing her listing clean and clear, no special flags, no unusual requirements. Patricia is lying. Not out of malice, but out of survival. She knows who Frank is, knows what he can make her workday look like if she contradicts him, knows that 18 years at a courthouse job means knowing when to see what you're supposed to see. The clock hits 8:59. 1 minute until her hearing. 1 minute until everything she's prepared for the past 2 weeks gets compressed into an absence that will read as unprofessional, unreliable, not serious about her client's constitutional rights. Simone reaches for her phone again, finds the number she memorized 3 years ago when she joined the Illinois State Bar Association's Criminal Justice Committee, the presiding judge's direct chambers line. "I need to make this call," she says. Frank grabs for her phone. His hand closes around her wrist, grip tight enough to hurt, tight enough to leave marks that will bloom purple by evening. Simone's body responds before her mind fully processes, not pulling away, that would give him excuse to claim she's resisting, but rotating her forearm inward, using the mechanical weakness in his grip, stepping back 2 paces with her hands visible and her phone still in her palm. The movement is too smooth to be accidental, too practiced. Frank notices, eyes narrowing with the recognition that this woman knows something he didn't expect. "You just assaulted a security officer," he says. "I removed your unauthorized hand from my person." Simone's voice stays level. "That's self-defense under Illinois Statute 720 ILCS 5/7-1. You committed battery by grabbing me without legal justification." Vernon's radio crackles. He steps away to respond, voice low. Comes back with his face set in the expression of someone who's decided something. "We're going to need to detain you until credentials are verified." "Detain me?" Now Simone's voice carries an edge. Not anger, but precision. "On what basis?" "Attempted unauthorized access to secure area." "I have valid credentials. You're preventing me from reaching a scheduled court hearing. That's obstruction. That's a serious accusation. It's a factual description." The courthouse clock above them all ticks to 9:01. The hearing has started. Right now, in courtroom 5B, Judge Kemp is looking at his docket and seeing defense counsel's name with no warm body attached. Right now, Marcus Wilson is sitting at the defense table alone, his mother and grandmother in the gallery, all of them wondering where she is. Right now, the prosecutor, Ashley Crane, late 20s, Yale Law, 3 years of treating Simone like a particularly persistent inconvenience, is probably smiling. Frank reaches for Simone's briefcase. "I'll hold on to this while we sort this out." That briefcase contains privileged attorney-client materials. She doesn't pull away, just states the fact clearly for any recording device within range. "You have no legal right to seize it. I'm securing potentially unauthorized items." He takes the briefcase anyway. Simone doesn't physically resist, but her voice carries across the lobby with courtroom projection. "I'm stating clearly, and for any recording devices, I do not consent to this search. This is a violation of attorney-client privilege under Illinois Rule of Professional Conduct 1.6. Vernon gestures toward the holding room adjacent to the checkpoint. Small office with a metal desk and 2 chairs, no windows. The kind of space designed to make people reconsider their choices. "Someone from the clerk's office will verify your status," Vernon says. Simone walks into the holding room under her own power because the alternative is being walked in, and she knows which one plays better on whatever footage might exist. The door closes, not locked, but shut with the kind of finality that makes the distinction academic. She sits in the metal chair, sets her phone on the desk, checks the time, 9:05. 5 minutes into her hearing, she dials Marcus's number. He answers on the first ring. "Ms. Harper, where are you? The judge is asking." "I'm being held at security. Tell the judge I'm in the building but being prevented from accessing the courtroom. Ask for a continuance." He looks angry. The connection cuts. Simone looks up. Frank stands in the doorway holding her phone, having snatched it from her hand while she was focused on the call. "No calls from holding," he says. He leaves. The door shuts again. Simone is alone with the fluorescent lights humming overhead, and the faint smell of industrial cleaner that all courthouse holding rooms share. She opens her briefcase. Frank set it on the desk but didn't actually search it, and pulls out a yellow legal pad. Starts writing. 8:47 a.m. Stopped at checkpoint 3 by Officer Frank Millstone. 8:52 a.m. Supervisor Vernon Blake called to verify credentials. 8:57 a.m. Credentials verified by Court Clerk Patricia Lamb. Notation claimed but not substantiated. 9:03 a.m. Briefcase seized without consent. Attorney-client privilege violation stated for record. 9:08 a.m. Phone confiscated during privileged client call. Sixth Amendment interference. She continues writing, each entry precise with direct quotes where she can remember them, paraphrased summaries where memory blurs. This habit comes from somewhere. From training that taught her documentation is weapon and shield both. From experience that proved the difference between she said and time-stamped contemporaneous notes say in administrative proceedings that decide who gets believed. 9:35. 38 minutes into the holding room. Her hearing should be wrapping up by now if it proceeded without her. Should be done, decided, finished. Simone closes her eyes for 3 seconds, opens them, adds another entry to her timeline. 9:35 a.m. Requested bathroom access. Denied by Officer Millstone with statement, "Should have thought of that before causing trouble." The door opens. Vernon, no Frank this time. "Your hearing has been continued to 10:30, he says. "That gives security 1 hour to resolve this." "How long will verification take?" "As long as necessary." He leaves. The door closes. Simone returns to her legal pad. Continues building the record that will matter later when official reports claim everything happened by the book, and her word is weighed against the institutional gravity of men in uniforms. In courtroom 5B, the scene plays out without her. Judge Kemp sits elevated behind his bench, 60 years old, white, 23 years on the bench, built on a reputation for fairness that doesn't extend to patience. "Ms. Harper?" His voice carries across the courtroom. "Your client is present, the prosecutor is ready, and you are where, exactly?" Marcus Wilson sits at the defense table, 17 years old, trying to look older in the suit his mother bought for this hearing. His hands shake slightly. He stands, voice cracking. "She called, Your Honor. She said security won't let her up." Judge Kemp's eyebrows rise. "Security? That's absurd. Bailiff, call down to the checkpoint." The bailiff, not Vernon, different man entirely, makes the call, returns looking confused. "Your Honor, they say they're verifying her credentials. There's some question about whether she's actually an attorney." The courtroom murmurs. Spectators in the gallery exchange glances. Marcus's mother, Denise Wilson, grips her own mother's hand tight enough to hurt. Both women know what it means when defense counsel doesn't show. Know it from cousins and neighbors, and the steady drumbeat of cases that collapse not from guilt, but from the small procedural failures that compound into convictions. "This is highly irregular," Judge Kemp's voice carries irritation. "But I cannot proceed without defense counsel. Motion hearing is continued to 10:30. That gives security." He checks his watch. 1 hour to resolve this nonsense. The gavel falls. Marcus slumps in his chair. His mother closes her eyes. Ashley Crane gathers her files with a small smile she tries to hide but doesn't try hard enough. This is just the beginning of what happens when the system underestimates the wrong person. Stay with us. Back in the holding room, Simone uses the time. Her briefcase contains more than just Marcus's case files. Contains her laptop, backup battery, 3 different colored pens for color-coded notes, protein bar for days when court runs long, business cards with her information embossed in raised lettering. She pulls out the laptop, opens a document titled Courthouse Access Documentation, 2024. Adds today's entry to a spreadsheet that already contains 43 previous dates, times, and brief descriptions of security interactions. Most entries are benign. 8:15 a.m., checkpoint 3, no delays. 9:42 a.m., checkpoint 1, bag check 3 minutes. Standard friction of moving through secured spaces. but 7 entries carry weight. Detained 12 minutes despite valid credentials. Required additional ID verification, 8 minutes delay. Asked to explain case business before being allowed through. 7 entries out of 44 visits. 1 in 6 times, something goes wrong. And now, entry 45. Detained 97 minutes and counting. She saves the file, backs it up to cloud storage, pulls up her email and starts drafting a message to Thomas Rivera at the Illinois State Bar Association Grievance Committee. Doesn't send it yet. She needs to know how this ends first, but prepares the framework. Subject: formal complaint. Courthouse access denial. Thomas, documenting for formal filing. November 14, 2024, 8:47 a.m. Denied access to court hearing despite valid credentials and case documentation. The door opens again. 10:25. Vernon, with Frank behind him this time. Your hearing is in 5 minutes, Vernon says. We still haven't received final verification from the presiding judge's office. Simone stands. You've had 90 minutes to verify credentials that Patricia confirmed an hour ago. I need to be in court in 5 minutes. We're following procedure. You're inventing procedure. Her voice stays calm despite the spike of adrenaline. There is no requirement for presiding judge verification of attorney credentials. You're making this up. Vernon's face hardens into the expression of someone who's decided this woman needs to learn her place. We can discuss your concerns after your hearing. For now, you'll wait. Simone moves toward the door. Frank blocks it, body filling the frame. You need to move, she says. I'm going to my hearing. Sit down. No. Frank's hand shoots out, grabs her upper arm. The grip is hard enough to bruise, fingers digging into the muscle above her elbow. Simone's training kicks in, not jerking away, that gives him the narrative he wants, but a controlled rotation that breaks his mechanical leverage, stepping back with her hands visible and her body language defensive, not aggressive. Take your hand off me, she says clearly. You're committing battery. Frank squeezes harder before releasing. You just assaulted a security officer. Vernon, call it in. Vernon keys his radio. Need assistance at checkpoint 3 holding area. Subject becoming aggressive. Aggressive. The word that transforms compliance into threat, that turns asking for basic rights into evidence of dangerous instability. Simone hears it and knows what's coming next because she's seen this pattern play out in case files and body cam footage and the careful neutral language of incident reports that describe anything but neutrality. 2 more security officers arrive within 90 seconds. Both white, both male, both in their 30s, with the body language of people who've decided this situation already. They flank the doorway behind Frank. Ma'am, we need you to calm down, the first one says. I am calm. Simone's voice proves it. I'm being illegally detained and denied access to my court hearing. Are you refusing to comply with security instructions? I'm stating that those instructions are unlawful. Frank pulls zip-tie restraints from his belt. Plastic strips designed for temporary detention, tight enough to hurt, visible enough to humiliate. We can do this the easy way or the hard way. Simone doesn't look at the restraints, looks at Frank's face instead. If you restrain me, you're violating 42 U.S.C. Section 1983, deprivation of rights under color of law. I'm an attorney attempting to reach my client's hearing. You have no legal basis to detain me. The citation lands like a stone. Frank hesitates, not because he cares about federal civil rights law, but because the precision of her language suggests she knows exactly what she's talking about. Vernon checks his watch. 10:28, 2 minutes until the continued hearing. Vernon's radio crackles. Courtroom 5B to security. Is Ms. Harper en route? Vernon looks at Simone, at Frank, at the 2 backup officers. Some calculation plays out behind his eyes. Stand by, he says into the radio. Then to Simone. Actually, we're not finished here. Her jaw tightens. First crack in the controlled composure she's maintained for 97 minutes. You're deliberately preventing me from reaching my hearing. We're following protocol. You're retaliating because I know my rights. The words hang in the air between them. Truth stripped of diplomacy, spoken clearly enough that any recording device will catch it. Vernon's face flushes. You'll wait until we're satisfied, he says. Simone pulls out her phone, the one Frank confiscated and left on the holding room desk, dials from memory, puts it on speaker before anyone can stop her. 3 rings, then a professional female voice. Presiding Judge Harriet Vance's chambers. This is Simone Harper, bar number 6284719. I'm being unlawfully detained at checkpoint 3 and prevented from accessing my 10:30 hearing in courtroom 5B. Frank reaches for the phone. Simone holds it away from him, voice calm and clear. I'm currently on speaker with the presiding judge's office. Security is attempting to interfere with this call. 1 moment, please. 30 seconds of hold. Vernon's face goes pale. Frank's hand drops. The 2 backup officers exchange glances that suggest they're reassessing which side of this encounter they want to be on. Ms. Harper? The voice returns, but different now. Older, authoritative. Judge Harriet Vance herself. This is Judge Vance. What's the situation? Your Honor, I've been detained for 1 hour and 43 minutes. Security refuses to accept my valid bar credentials and court documentation. I'm currently being held in a room adjacent to checkpoint 3. Who is the senior officer present? Vernon steps forward, takes the phone off speaker. Vernon Blake, Your Honor. We were following protocol for... Judge Vance's voice cuts through, loud enough to hear even without speaker. I don't care about your protocol. Ms. Harper is a member of the bar in good standing. Release her immediately and send her to courtroom 5B. I'll be filing a report with court administration. The call ends. Silence fills the holding room like water-filling lungs. Vernon hands the phone back to Simone, without meeting her eyes. Frank steps aside from the doorway, face red with anger that has nowhere safe to land. I'll need my briefcase as well, Simone says. Frank practically throws it at her. She catches it, checks the contents, everything still there despite the earlier seizure, pulls her phone into her jacket pocket, straightens her collar, walks out of the holding room with her head up and her stride measured, not running despite the 2 minutes she has to reach the 5th floor. She passes Patricia's desk on the way to the elevators. The clerk looks up, mouths "I'm sorry," without sound. Simone nods once. Not forgiveness, not condemnation, just acknowledgement that they're both navigating the same system with different levels of protection. The elevator ride takes 45 seconds. Simone checks her reflection in the polished metal doors. Hair slightly disheveled, collar askew from where Frank grabbed her. She smooths both, professional mask sliding back into place, opens her briefcase, verifies her notes are still in order, motion arguments still tabbed and ready. The elevator opens on the 5th floor. Courtroom 5B is at the end of the hall, double doors propped open. 10:34. 4 minutes late, but she's here. She's made it. Simone enters through the rear doors. The courtroom is half full. Marcus at the defense table, his family in the gallery, Ashley Crane at the prosecution table reviewing her notes with the confidence of someone who thought this hearing would go uncontested. Judge Kemp looks up from his paperwork. Ms. Harper, how gracious of you to join us. The sarcasm cuts, designed to embarrass. Simone doesn't react to the tone. My apologies, Your Honor. I was detained at courthouse security from 8:47 until 10:31. Detained? Judge Kemp's eyebrows rise. For what reason? They refused to accept my credentials. The courtroom murmurs. Gallery spectators lean forward. Judge Kemp frowns, something shifting in his expression, not quite concern, but the beginning of recognition that something irregular has occurred. That's highly unusual, he says. We'll address it later. Are you prepared to proceed? Yes, Your Honor. Simone moves to the defense table, sets her briefcase down. Marcus looks up at her with eyes that hold relief and confusion and the beginning of a question. She gives him a small nod that says later, not now, turns to face the bench with her notes open and her arguments ready and her voice steady despite the 97 minutes that tried to break that steadiness. Your Honor, Defense moves to suppress all evidence obtained during the warrantless search of my client's vehicle on October 3, 2024. The search violated his Fourth Amendment rights as established in Illinois versus Rodriguez and numerous subsequent cases affirming that odor alone does not establish probable cause for vehicle search without additional articulable factors. She speaks for 12 minutes, cites cases from memory, references specific page numbers in the transcript of the suppression hearing held 2 weeks prior, dismantles the prosecution's probable cause argument piece by careful piece. Ashley Crane objects 3 times, each objection weaker than the last because Ashley prepared for an uncontested hearing, not for Simone showing up with the kind of focused intensity that comes from having to fight for every inch of ground. Judge Kemp takes notes, asks 2 clarifying questions, looks at Ashley. Prosecution's response? Ashley stands, smooths her skirt, delivers the arguments she prepared. They're competent but not inspired, relying heavily on the arresting officer's testimony without addressing the gaps Simone identified in that testimony. She speaks for 7 minutes, sits down. "I'll take this under advisement," Judge Kemp says. "Decision by end of business Friday." Gavel falls. Hearing adjourns at 10:58. Marcus turns to Simone as the courtroom empties. "What happened? Why wouldn't they let you in?" His mother appears at the railing that separates gallery from court well. "Miss Harper, are you all right? They detained you?" Simone closes her briefcase. "It's handled. Let's focus on your son's case. The motion arguments were strong. Judge Kemp will rule by Friday." "But that's not fair," Marcus says. "You almost missed the hearing because—" "Marcus," her voice stays gentle but firm, "I made it. That's what matters." What she doesn't say, this is a burden you don't need to carry. This is a weight that's mine to manage. This is the reality of practicing law while black in spaces built to question your presence. But you have enough to worry about without taking on my battles too. They walk out together, Simone answering questions about what happens next, when they'll hear from the judge, what the ruling might mean for the case. Professional conversation that creates distance from the personal violation of the past 100 minutes. In the hallway outside the courtroom, Ashley Crane approaches. "Simone, I heard about the security thing. That's terrible." Simone stops walking, meets Ashley's eyes with the kind of direct gaze that makes the younger woman falter. "You told Vernon you didn't know me." "I was caught off guard. I didn't want to overstep." "You lied to help them detain me." "That's not what I—" "We're done here." Simone walks away. Ashley's mask of concern slips just enough to show something underneath. Guilt, maybe, or calculation, or the complicated arithmetic of someone who knows they made the wrong choice but can't quite commit to acknowledging it. The rest of the day moves in fragments. Simone returns to her office, small space in a shared suite with 3 other solo practitioners. Updates her case management software with notes from the hearing. Eats the protein bar from her briefcase because lunch feels impossible. Drafts the email to Thomas Rivera that she started in the holding room, this time with the full story and a request for formal complaint procedures. 2:15. She walks 6 blocks to the Illinois State Bar Association offices, modern building that smells like new carpet and the kind of quiet that comes from sound-dampening walls. Thomas Rivera meets her in a small conference room, 50 years old, black, 23 years practicing law, including 12 on the grievance committee. "Simone, I got your email. This is serious." "I have documentation." She pulls out the yellow legal pad, the timeline written in her careful handwriting, walks him through each entry, each violation, each moment when procedure became weapon. Thomas takes notes, records the conversation with her permission. When she finishes, he sits back in his chair with the expression of someone who's heard versions of this story before but never quite like this. "The duration alone is actionable," he says. 97 minutes for credential verification that was completed in the first 10? That's not procedure, that's harassment. I want to file a formal complaint. Against the individual officers or the courthouse itself? Both. Thomas nods slowly. I'll need to call some witnesses, Patricia Lamb for one. Get her on record about what she actually verified. He makes the call. Patricia answers, voice guarded. Thomas puts it on speaker with a glance at Simone for permission. Ms. Lamb, this is Thomas Rivera from the State Bar Grievance Committee. I'm calling about an incident this morning involving attorney Simone Harper. You verified her credentials around 8:57 a.m.? Silence on the line. Then quietly, yes, she's in good standing. Bar number 6284719, active since 2017. Did you note any problems with her credentials? Another pause, longer this time. No, her registration was valid. Yet security continued to detain her for another 90 minutes? I can't speak to their decision-making process. The call ends. Thomas makes another note. She verified you but then lied about a notation. Classic institutional compliance. Go along to get along. We can work with that. He pulls up a database on his laptop. I'm going to request security checkpoint logs. See if there's a pattern. The request goes through official channels, sent to courthouse administration with the weight of Bar Association authority behind it. By 3:30 p.m. the data arrives. Thomas opens the spreadsheet, scrolls through 6 months of entries. His face hardens as the numbers tell their story. 37 credential verification holds in 6 months, he reads aloud. Average duration for white attorneys, 11 minutes. Average duration for black attorneys, 43 minutes. Your 97 minutes is the longest on record. He turns the laptop so Simone can see. The data sits in neat columns, sortable by date and time, and officer name and attorney demographics. A pattern so clear it could be a photograph. How is this the first time anyone's reported it? She asks. People report it. Complaints get filed. Then they disappear into administrative review and nothing changes. Thomas closes the laptop. Not this time. If this story is making you angry, channel that into action. Subscribe so you don't miss what happens when the system finally gets held accountable. The next morning, Simone wakes at 6:30 to an email from courthouse administration. Subject, security footage request, checkpoint 3. The email is brief, professional, notifying her that pursuant to Bar Association subpoena, the requested footage has been preserved and will be delivered to the grievance committee by close of business. She makes coffee, reviews her other cases, 2 client meetings this morning, 1 preliminary hearing this afternoon. Normal work that helps ground her after yesterday's chaos. But the email sits in her inbox like a weight, reminder that this fight is just beginning. By 9 a.m., she's in Thomas Rivera's office watching security footage on a large monitor. Lisa Chen, the Bar Association's investigator, sits beside them making notes. The video plays in segments. 8:47 a.m. Simone approaches checkpoint 3. Frank stops her immediately. 5 seconds later, a white male attorney in his 60s passes through unchallenged. 8:52 a.m. Frank examines her bar card for 38 seconds while Vernon is called. The timestamp shows every second of unnecessary scrutiny. 8:57 a.m. Patricia at her computer terminal, clearly visible typing Simone's information, nodding at her screen. The verification that should have ended everything. 9:03 a.m. Frank seizes the briefcase. Simone's voice clear on the audio. I do not consent to this search. This is a violation of attorney-client privilege. 9:08 a.m. Frank confiscates her phone during the call to Marcus. The audio catches her mid-sentence, explaining the delay, then the abrupt silence as the phone is taken. 10:28 a.m. Vernon on the radio with Judge Vance's chambers. The moment his face goes pale. The immediate pivot to releasing Simone. Lisa pauses the video at several points, making notes about body language, proximity, the physical grab that constitutes battery under Illinois law. Thomas sits forward in his chair, fingers steepled, watching with the focus of someone building a case. This is textbook civil rights violation, he says. But there's something else. Lisa, pull up Vernon's training records. Lisa switches to a different database. What am I looking for? Implicit bias training, last 6 months. The records populate. Vernon Blake attended a training session 6 months ago. Reducing bias in courthouse screening procedures. 15 participants. Lead presenter, Simone Harper. The silence in the room feels heavy. Thomas looks at Simone. He knew who you were. I presented for 90 minutes on exactly this kind of gatekeeping. Vernon sat in the third row. Asked 2 questions during Q&A. So this wasn't random screening. This was targeted retaliation. Lisa makes a note. That changes the legal exposure significantly. This isn't just harassment. It's retaliation against someone who'd criticized the system. Thomas pulls up more records. Vernon's incident reports over the past year. 42 security concerns logged at his checkpoint. 38 involved people of color. Of those 38, 12 were attorneys. Simone's name appears twice in the past 6 months, both times with notations about extended verification procedures. He's been documenting you, Thomas says, building a file to justify exactly what happened yesterday. The pieces fall into place. Vernon recognized her from the training, knew she was on the ISBA Criminal Justice Committee, knew she testified before the state legislature about courthouse access barriers, and when she showed up at his checkpoint, he saw an opportunity to make an example of someone who'd made his job harder by demanding it be done correctly. What happens now? Simone asks. Now we file a formal complaint with the Illinois Supreme Court Attorney Registration and Disciplinary Commission. We request a hearing. We present this evidence. Thomas taps the monitor. And we push for actual consequences. 1 week later, the disciplinary hearing convenes in a conference room that smells like furniture polish and the weight of institutional authority. 3-judge panel sits at an elevated table. Judge Marianne Osterholm in the center, 2 colleagues flanking her. Thomas Rivera sits at the complainant's table with Simone. Across the room, Frank Millstone and Vernon Blake sit with their union attorney, David Kowalski, 50 years old and cynical about everything except his billable hours. The panel chair gavels the hearing to order. We're here to address complaint number 2024-GC-4721, filed by attorney Simone Harper against courthouse security personnel Frank Millstone and Vernon Blake. Ms. Harper alleges unlawful detention, violation of attorney-client privilege, and obstruction of access to court proceedings. Thomas stands. Your Honor, the evidence will show a pattern of discriminatory treatment at Checkpoint 3, culminating in a 97-minute detention of a licensed attorney with valid credentials and urgent court business. We have video evidence, statistical data, and testimony demonstrating that this was not an isolated incident, but part of a systematic problem. David Kowalski rises to respond. Your Honor, Mr. Millstone and Mr. Blake followed standard security protocols. They had legitimate concerns about credential verification in an era when courthouse security is paramount. Any delays were procedurally justified. Judge Osterholm looks at Simone. Ms. Harper, please describe the events of November 14th. Simone stands, speaks clearly, factually, without emotion bleeding into the recitation. She walks the panel through each moment, stopped at 8:47, credentials verified at 8:57, but detention continued, phone confiscated during privileged client call, released only after the presiding judge intervened. What was your emotional state during this detention? Judge Osterholm asks. Focused on reaching my client's hearing. Not angry? Not frightened? Anger wouldn't have helped. Fear wouldn't have changed anything. I documented what happened and called the appropriate authority. The answer lands with the weight of someone who's learned survival requires control, not reaction. Judge Osterholm makes a note. Thomas presents the security footage. The panel watches in silence as the timeline plays out in grainy video and clear timestamps. When Frank grabs Simone's arm, one of the panel members winces visibly. David Kowalski cross-examines. Ms. Harper, you cited several legal statutes during this encounter. Where did you learn those? Law school, practice, continuing legal education. But you cited them from memory, without looking anything up. That's unusual, isn't it? I serve on the ISBA Criminal Justice Committee. I teach trial advocacy at Northwestern. Constitutional law is part of my daily work. So you would say you have specialized knowledge about police procedures and civil rights law? I would say I have the knowledge any competent criminal defense attorney should have. The response deflects the trap Kowalski was setting, trying to make her expertise seem suspicious rather than professional. Judge Osterholm intervenes. Mr. Kowalski, is there a question here, or are you just establishing that Miss Harper knows the law she's licensed to practice? Kowalski sits down. Thomas calls Vernon Blake to testify. Mr. Blake, did you recognize Miss Harper when you arrived at the checkpoint? Vernon's face stays neutral. I may have seen her before. You attended a training she led 6 months ago, implicit bias in courthouse screening. Is that correct? I attend a lot of trainings. Thomas projects the training attendance sheet on the screen. According to these records, you signed in for that session. There were only 15 participants. Ms. Harper was the lead presenter for 90 minutes. You asked 2 questions during the Q&A session. Do you recall that now? Vernon's jaw tightens. I remember the training. So you knew exactly who she was when she arrived at your checkpoint. You knew she was an attorney. You knew she served on the committee that oversees security protocols. And you detained her anyway. Why? I was following Frank's assessment. He's the senior officer. You're a veteran bailiff with 32 years' experience. You've served on security details for visiting federal judges and handled high-profile cases. You knew this detention was unlawful, but you participated anyway. Why? Silence stretches for 10 seconds. Judge Osterholm leans forward. Mr. Blake, answer the question. Vernon's shoulders sag slightly. I made an error in judgment. An error that cost Ms. Harper 97 minutes, nearly caused her client's case to be dismissed by default, and violated multiple constitutional rights. That's not an error, Mr. Blake. That's a choice. Patricia Lamb testifies next, called as a witness despite her obvious reluctance. She takes her seat with her hands folded, eyes downcast. Ms. Lamb, you verified Ms. Harper's credentials at 8:57 a.m. What did you tell security? Patricia's voice comes out quiet. I told them she was on the roster, active status, no issues. Did you mention any notation requiring in-person verification? Long pause. Patricia looks at Simone, then away. No, there was no notation. I made that up. The courtroom stirs. Judge Osterholm's pen stops mid-note. Why would you fabricate that information? Because Frank was standing right there. Because I've seen what happens to people who contradict him. Patricia's voice strengthens slightly. Because I'm a black woman working in a system that punishes you for making waves, and I was scared. She looks directly at Simone now. I'm sorry. I was a coward. You deserved better. The admission lands like a confession, stripping away the professional distance that usually protects testimony from raw truth. Judge Osterholm makes several notes. The other panel members exchange glances. Thomas presents the statistical evidence next. 6 months of checkpoint data projected on screen, sortable by race, showing the pattern that transforms individual incidents into systemic discrimination. 37 credential verification holds, Thomas narrates. 31 involved black attorneys. Average detention time, 43 minutes for black attorneys versus 11 minutes for white attorneys. Ms. Harper's 97 minutes represents the most extreme example of a documented pattern. David Kowalski objects. These statistics don't account for legitimate security concerns that might correlate with what, Mr. Kowalski? Judge Osterholm's voice cuts sharp. Please complete that sentence. What legitimate security concern correlates with skin color? Kowalski closes his mouth, sits down. The panel deliberates for 40 minutes. When they return, Judge Osterholm delivers the verdict with the careful weight of someone who knows this decision will be cited in future cases. After reviewing video evidence, statistical data, and testimony from multiple witnesses, this panel finds that Mr. Frank Millstone and Mr. Vernon Blake violated Illinois Supreme Court Rule 8.4d, engaging in conduct prejudicial to the administration of justice. They are hereby suspended from courthouse duties pending completion of mandatory bias training and probationary review. The gavel falls, not termination. The union protections prevent that without criminal charges. Not complete justice. The system protects its own even when caught. But something. Progress measured in inches, not miles. Simone exits the hearing room to a small crowd of supporters, other black attorneys who've faced similar gatekeeping, law students who've heard her speak at Northwestern, Marcus Wilson's family, who came to witness the woman who fought for their son fight for herself. Denise Wilson approaches first. "Thank you for not backing down." "I fought it for me," Simone says honestly, "but I'm glad it helps others." Thomas appears at her elbow. "This is going to make waves. The data alone, other courthouses are going to have to examine their own practices." Will they? Simone's skepticism comes from experience. Some will, because now there's a record, now there's precedent. Now other attorneys know they can fight back and win. Her phone buzzes. Email from Presiding Judge Vance. Subject: Courthouse Access Protocol Revision. Simone opens it, reads quickly. The email announces immediate reforms. Electronic credential scanners mandatory at all checkpoints. Manual, judgment-based holds prohibited. Direct line to presiding judge's office for any attorney denied access. The changes are named the Harper Access Protocol. Her name on institutional reform. Permanent marker of this fight. Simone looks at the email for a long moment, something complicated moving through her chest. Not quite satisfaction, not quite vindication, but recognition that small victories matter even when the larger war continues. 2 weeks pass. Judge Kemp issues his ruling on Marcus Wilson's motion to suppress. Granted. Evidence obtained during the illegal search is inadmissible. Without that evidence, the prosecution has insufficient remaining proof. Ashley Crane files a motion to dismiss charges. Marcus calls Simone at 4:30 on a Friday afternoon, voice breaking with relief and disbelief. "Ms. Harper, they're dropping the charges. I'm free?" "You're free." She can hear his mother crying in the background, the sound of a family reclaiming a future that had been compressed into worst-case scenarios. Simone allows herself a small smile, alone in her office with case files stacked on every surface, and the kind of tired that comes from fights won at cost. 1 month after the hearing, Simone returns to the courthouse for a different case. Approaches. Checkpoint 3 with her briefcase and her credentials, and the muscle memory of 97 minutes that tried to teach her she doesn't belong. Different security guard working the checkpoint. Young, maybe late 20s, posture nervous but professional. New sign posted beside the metal detector. Attorney access. Present bar card for electronic scan. Manual verification prohibited. Questions. Contact presiding judge's office at extension 4400. "Good morning," the guard says. "Please scan your card here." Simone places her bar card on the scanner. Green light. Beep. He nods her through. Start to finish, 45 seconds. The way it should have been the first time. The way it will be for the next attorney, and the one after that, because systems change slowly, but they do change when pushed hard enough by people who refuse to accept that this is just how things are. She takes the elevator to the 5th floor, thinking about the price of that 45 seconds. The 97 minutes it cost. The hearing and the testimony and the statistical evidence, and Patricia's quiet apology, the ways small victories require large investments. In the hallway she passes a young black woman, law student maybe or junior attorney, hard to tell, who walks toward the elevators with her briefcase and her credentials, and no visible anxiety about what waits at the checkpoint below. The woman doesn't even notice how smoothly her morning is proceeding because she doesn't know how rough it used to be. That's the victory. When access becomes so routine it's invisible. When the next generation doesn't have to fight the same battle. When the system adjusts just enough that one barrier falls, even as others remain standing. Simone reaches her courtroom, enters through the rear doors, takes her place at the defense table for another case, another client, another day of practicing law in spaces that question her presence but can't quite deny it anymore. 6 weeks later, she guest lectures at Northwestern Law School. The classroom holds 40 students, mostly younger than 25, eyes bright with the kind of optimism that law school hasn't yet complicated with reality. Courthouse access seems like a small thing, she tells them. getting through security. But access is everything. If they can keep you out of the building, they can keep you out of the system. If they can delay you 97 minutes, they can derail your client's case. This is how gatekeeping works, not through dramatic confrontations, but through procedural friction. A student raises her hand. How do you stay calm when that happens? You document everything. You cite the rules they're violating, and you remember, their discomfort with your presence is not your problem to solve. Your job is to represent your client. Let them explain their behavior later. Another hand. But what if they don't care about the rules? Then you make them care. You file complaints. You preserve evidence. You build records that force accountability, even when the people in power would prefer to avoid it. She pauses. It's exhausting. It's unfair that you have to do this work on top of the actual legal work you're being paid to perform. But until the system changes more fundamentally, documentation is both weapon and shield. Use it. The lecture ends. Students file out, some approaching with questions, others just nodding their thanks. Simone packs her notes, thinking about the ways teaching transforms experience into tool, personal violation into lesson plan, survival into strategy that might help the next person who faces the same barrier. That evening, alone in her apartment, Simone receives an email. Anonymous sender. Subject line. You're not the only one. Body text. Check courthouse detention logs from 2019 to 2021. Cross-reference with bar demographics. The pattern goes back further than you think. A friend in records. The email self-destructs 30 seconds after she reads it, disappearing into whatever encrypted system the sender used to protect their identity. But the message lingers. Someone inside the courthouse is watching. Someone is documenting. Someone wants her to know that the fight she started reveals problems deeper than one checkpoint, older than 6 months of data, more entrenched than 2 security guards. Simone pulls up the public records request form on the state website, types in her information, specifies the date range 2019 to 2021, requests all credential verification logs from checkpoints 1 through 6. Submits it. The data will take weeks to arrive. Will require analysis and cross-referencing, and the kind of careful statistical work that builds cases brick by methodical brick. But she has time, has experience, has the muscle memory of documenting injustice until it can't be denied. Her phone rings. Thomas Rivera. Bar Association wants you to join the Courthouse Access Reform Task Force. We're presenting recommendations to the state legislature next session. Simone sits on her couch, coffee growing cold on the table beside her. I'll consider it. Consider it over dinner? I'd like to discuss the work and other things. A pause. She processes the shift in his tone from professional to something adjacent. Other things? I've admired your work for a while. Thought maybe we could talk about it. Away from hearing rooms and formal complaints. Professional or personal conversation? Could be both. Simone finds herself smiling despite the weight of everything. I'll check my calendar. Is that a yes? It's a maybe. I don't commit to things without reviewing all available information first. Thomas laughs, warm and genuine. Spoken like a true attorney. I'll email you some potential dates. They hang up. Simone sits in the quiet of her apartment, thinking about the ways life continues forward, even while fighting battles with the past. The way small personal moments thread through large systemic struggles. The way maybe dinners and reform task forces and anonymous tips all coexist in the same week, the same day, the same hour. 3 months later, she walks past checkpoint 3 and sees the young black woman from before, definitely a law student, based on the casebook visible in her tote bag, being waved through after a quick card scan. The student doesn't pause, doesn't even register how smoothly the interaction proceeded, because she doesn't know it used to be different. That's the goal. Not glory or recognition or her name on protocols, though those came anyway. The goal is one less barrier, one less 97-minute wait, one less fight that someone else won't have to wage. 6 months after the hearing, Simone is invited to speak at a different county courthouse about attorney access rights. She arrives early, approaches the security checkpoint with her credentials ready and her briefcase packed with presentation materials. Different guard, different building, same energy in the way his eyes track her approach, some calculation happening behind professional neutrality. "Are you here for community court?" he asks. "That entrance is around back." Simone takes a slow breath, measures him with the kind of steady gaze that comes from having lived this scene before. "I'm here for the legal education session. I'm the presenter." "You're a lawyer?" "I am." "I'm going to need to verify that." She doesn't sigh, doesn't argue, just pulls out her phone, opens her voice memo app, checks her watch to note the time, starts building another timeline because documentation is power and she's very, very good at keeping records. "Of course you do," she says. The guard reaches for his radio. Simone holds her phone steady, recording icon blinking red. Some battles you win, some you fight again and again, until the system learns, or breaks, or both. But this time, she's not alone in the fight. This time, there's precedent with her name on it. This time, the presiding judge's direct number is already programmed in her phone, and the Bar Association investigator is one call away, and the Harper Access Protocol exists specifically for moments like this. This time, when she walks into that courthouse an hour from now, because yes, it will take time, it always does, she'll walk in with case law and complaint forms and the kind of quiet power that comes from having fought this battle before and won. Some systems resist change, but resistance isn't the same as immunity, and Simone Harper is patient, meticulous, and absolutely relentless when it comes to dismantling barriers, one documented violation at a time. The recording continues. The timeline begins, and somewhere in a courthouse records office, an anonymous ally prepares to send another email when this interaction inevitably generates the evidence they've been waiting for. The fight isn't over. But neither is she. The second courthouse detention unfolds with the mechanical precision of institutional muscle memory. Different building, different county, same script. Guard radios for supervisor. Supervisor appears with reading glasses and skepticism. Credentials examined, scanner bypassed. Manual verification required per protocol. Simone documents. Timestamps. Records. Her voice stays level when she states clearly for any recording device. "I'm attorney Simone Harper, bar number 6284719, here to present at the legal education session starting in," she checks her watch, "43 minutes. This is the second time I've been detained at courthouse security in 6 months. I'm documenting this interaction under Illinois transparency statutes," the magic words. Second time, and documenting, and transparency statutes. The guard's hand hesitates on his radio. The supervisor's expression shifts from bureaucratic certainty to something more cautious. "Let me make a call," the supervisor says. But Simone is already dialing. Not the presiding judge this time. She's in a different jurisdiction, different power structure. Instead, she calls Thomas Rivera, now formally her colleague on the Courthouse Access Reform Task Force, and informally, something else that's still being defined over dinners that mix strategy sessions with personal conversation. "Thomas, I'm being detained at McLean County Courthouse. Second incident." His voice sharpens immediately, professional mode activating. "How long?" 7 minutes so far." "Put me on speaker." She does. Thomas identifies himself to the supervisor, attorney credentials and task force position deployed like artillery. "I'm documenting this detention as part of our statewide courthouse access study. Your name and badge number will be included in our legislative report. Are you certain you want to continue preventing a licensed attorney from accessing a scheduled educational session?" The supervisor releases Simone within 90 seconds. She makes it to the presentation with 36 minutes to spare. 36 minutes she uses to add this incident to the growing database. Incident number 48, tracked alongside the original 37 from her home courthouse, cross-referenced by county, demographics, duration, resolution. The pattern emerges with statistical clarity, not isolated incidents, not random security concerns, a systematic barrier that manifests with algorithmic precision. Black attorneys detained 4 times longer than white colleagues. Additional verification requested in 68% of black attorney encounters versus 9% for white attorneys. Numbers that transform personal experience into undeniable evidence. This gets bigger than anyone expected. Don't miss what happens when one attorney's fight becomes a movement. The legislative hearing convenes 3 months later in Springfield. Illinois State Capitol Building, committee room filled with representatives, advocates, courthouse administrators trying to get ahead of the narrative before it crushes them. Simone testifies for 18 minutes, no emotion, just data. Spreadsheets projected on screens. Video footage from Checkpoint 3. Statistical analysis showing the pattern across 14 counties. These numbers represent more than detention times, she tells the committee. They represent missed hearings, defaulted cases, clients whose constitutional rights were compromised because their attorneys couldn't reach the courtroom. This is how systemic discrimination operates, not through explicit policy, but through procedural friction that accumulates into barrier. Representative Michelle Okafor, black woman in her second term, leans forward. Ms. Harper, you mentioned 48 documented incidents. How many went unreported? Unknown. Most attorneys don't document because they're focused on reaching their hearings. They absorb the delay and move forward. Only when I started asking did I realize how widespread this was. So we're seeing the tip of the iceberg. I believe so, yes. David Kowalski sits 3 rows back, no longer representing Frank and Vernon, but watching as union observer. His face carries the tight expression of someone watching their institutional protections erode in real time. The committee votes 7-2 in favor of new legislation. Mandatory electronic verification at all courthouse security checkpoints. Prohibition on manual, judgment-based holds. Quarterly demographic reporting on detention times. Civil liability for violations. Not perfect. Enforcement mechanisms are weak. Penalties mostly administrative. But movement. Progress measured in statutory language that will outlast any individual incident. Governor signs it 4 months later. The Harper Courthouse Access Act becomes law January 1st. Simone watches the signing ceremony via live stream from her office, coffee growing cold as the governor speaks about transparency and equal access and the importance of removing barriers to justice. Her name spoken 3 times in official remarks. Her story compressed into soundbite. Personal violation transformed into legislative achievement. Thomas texts, "We did it." She types back, "First step, implementation is everything." Because she knows better than to celebrate before seeing whether the law actually changes behavior or just creates new paperwork requirements that get buried in administrative process. 2 weeks after the law takes effect, Patricia Lamb reaches out. Email to Simone's office address. Subject line simple. "I'm sorry, can we talk?" They meet at a coffee shop equidistant from both their homes. Patricia arrives first, nervous energy visible in the way she grips her cup with both hands. "I know you probably hate me," Patricia says when Simone sits down. "I don't hate you. I understand the position you were in. That doesn't make it okay." "No. But understanding why people comply with unjust systems doesn't mean excusing it. It means recognizing that systemic change requires addressing both individual choices and the structures that make those choices feel necessary." Patricia nods slowly. "I testified against them eventually. After you filed the complaint. It cost me, got transferred to a different courthouse, lost my seniority, but I sleep better." "Good." They sit in silence for a moment. 2 black women on different sides of the same system, both navigating spaces that demand pieces of themselves as price of access. "I wanted you to know something," Patricia says quietly. "That notation I made up? Vernon told me to do it. Said if I didn't back his play, I'd be the next one with credential problems, with workplace irregularities that would cost me my job. Did you document that?" "No, I was too scared." She meets Simone's eyes. "But I'm documenting now, everything. And there's more. Vernon wasn't working alone. Simone sets down her coffee. Explain. There's a group, not official, just security officers, and a few administrators who coordinate about problem attorneys. They have a list. Your name was on it 6 months before you got detained. So were 8 other black attorneys, 3 Latino attorneys, 1 white attorney who handles police misconduct cases. The information lands like a stone breaking water, ripples spreading outward into implications Simone is already calculating. How do you know this? I process the paperwork. I see the patterns. I kept quiet because I thought I had to. But that law you got passed? It has a whistleblower protection provision. Thomas Rivera called me last week to explain it, so I'm using it. Patricia pulls out a folder. Inside, printed emails marked confidential, security coordination. Exchanges between Vernon Blake and Courthouse Administrator Stuart Hammond discussing attorneys to watch. Simone's name appears 7 times across 4 months of messages, flagged for additional scrutiny after her implicit bias training session. This is retaliation, Simone says, reading through the emails. Coordinated retaliation against attorneys who criticized security procedures. That's what I thought. But I'm not a lawyer. I needed someone who could actually use this. Can I keep these? Patricia pushes the folder across the table. I made copies, kept the originals somewhere safe, in case something happens to me. The paranoia isn't unjustified. Whistleblowers who expose systemic corruption face professional retaliation that's hard to prove and harder to stop. Patricia is taking a real risk by coming forward with documentation that implicates not just individual officers, but courthouse administrators who enabled them. Simone pulls out her phone. I'm going to call Thomas. Then we're going to the Bar Association office. Together. You're not doing this alone. Patricia's shoulders drop with relief, visible enough to suggest she'd been bracing for a different response. Thank you. Don't thank me yet. This is going to get ugly. The investigation expands like a cancer diagnosis, each new test revealing more extensive damage than the previous scan suggested. Thomas brings in Lisa Chen, who brings in 2 more investigators. They request communications records from 14 courthouses. Most resist, citing administrative privilege or security concerns. Federal subpoenas override those objections. The emails paint a picture of systematic targeting, not just random bias or individual prejudice, but coordinated effort to make life difficult for attorneys who challenged courthouse operations. The list Patricia mentioned contains 23 names, 18 attorneys of color, 3 white attorneys who handle civil rights cases, 2 public defenders known for aggressive constitutional challenges. Vernon Blake's messages are particularly damning. Harper did that training last month, making us look like racists. Need to slow her down. Document everything with these problem lawyers. Build files, so when they complain, we have justification. Hammond approved extended verification protocols for anyone on the list. We're covered. Stuart Hammond, courthouse administrator, 4th tier management, whose name Simone had never heard before this investigation. Turns out he'd been coordinating with security to create exactly the kind of irregularities Patricia had been threatened with. Delays, credential questions, procedural friction that accumulated into barrier. The scope keeps expanding. 6 counties, 47 attorneys targeted over 3 years, hundreds of delayed hearings, dozens of defaulted cases, unmeasurable impact on clients whose representation was compromised by gatekeeping designed to punish their lawyers. Thomas calls a press conference 4 months into the investigation. Simone stands beside him at the podium, Lisa Chen on her other side, while Thomas reads from prepared remarks that compress months of investigation into 3 minutes of sound-bite-ready summary. Today, we're releasing a report detailing systematic retaliation against attorneys who advocated for courthouse access reform. The evidence shows coordinated targeting across 6 counties, affecting 47 attorneys, resulting in at least 83 delayed or defaulted hearings. This wasn't bias. It was retaliation. And it was deliberate. The questions come rapid fire. Who authorized this? How high does it go? Will there be criminal charges? Thomas fields them with practiced calm, providing just enough detail to satisfy without compromising ongoing investigations. Simone stays silent, presence serving as visual reminder that this isn't abstract policy discussion. It's about real attorneys, real cases, real clients whose rights were compromised. The fallout cascades through courthouse administration, like dominoes engineered to fall in sequence. Stuart Hammond resigns within 48 hours, citing personal reasons that everyone understands mean getting ahead of termination. Vernon Blake is fired outright, union protections unable to shield him from documented evidence of coordinated retaliation. Frank Millstone takes early retirement with reduced pension, negotiated settlement that avoids formal termination. 5 other security officers across multiple courthouses face disciplinary action ranging from suspension to mandatory retraining. 3 administrators are reassigned to positions without security oversight. Not perfect justice. None of them face criminal charges because the coordination, while unethical and employment violating, doesn't quite meet criminal conspiracy thresholds. But consequences. Accountability. The slow machinery of institutional reform grinding forward. Representative Okafor introduces additional legislation. Civilian oversight boards for courthouse security, mandatory bias training every 6 months instead of annually, direct hotline to the Attorney General's office for access complaints. The bills pass with bipartisan support because opposition would require defending the indefensible, and even politicians who privately resist reform understand when the political cost outweighs ideological preference. 6 months after the press conference, Simone receives an envelope at her office. Heavy paper, official seal, return address from the Illinois Supreme Court. She opens it expecting routine bar correspondence. Inside, invitation to the annual Illinois Lawyers Awards ceremony. Her name listed under the Justice and Equality category for her work on courthouse access reform. She reads it twice, processing the strange dissonance of institutional recognition for work that involved fighting against institutional barriers. The system honoring her for forcing it to change feels like complicated irony she's not sure how to interpret. Thomas calls 5 minutes later. Did you get the invitation? Yeah. Did you nominate me? Lisa did. I seconded it. You deserve recognition for what you did. I documented what happened to me. That's not heroic. That's survival. Survival that changed the system for everyone else. That's exactly what deserves recognition. Simone doesn't argue, but she doesn't commit to attending either. The ceremony is 3 months away. She'll decide later whether accepting an award for fighting the system from people who represent that system feels like victory or compromise. The next morning brings different mail. Handwritten envelope, no return address, postmarked from somewhere in southern Illinois. Inside, a single sheet of notebook paper with 3 sentences written in careful block letters. Your investigation stopped at 6 counties. There are 15 more with the same patterns. We're watching. We're documenting. We're ready when you are. No signature, no contact information, just those 3 sentences and the weight of implication that this fight is bigger than even the expanded investigation revealed. Simone photographs the letter, files it in the expanding folder she keeps for anonymous tips and unexplained communications that arrive whenever her work generates publicity. Adds it to the list of threads she'll pull when time permits, when resources allow, when the current cases leave space for the next battle. Because there's always a next battle. The system is vast and self-protecting and capable of regenerating damaged pieces faster than reformers can dismantle them. But each fight leaves scars that make the next one slightly easier. Each victory establishes precedent that the next attorney can cite. Each barrier torn down makes space for someone who won't have to fight the same fight. 2 months before the awards ceremony, Marcus Wilson graduates from community college, associate's degree in criminal justice, plans to transfer to a 4-year program for his bachelor's. His mother sends Simone an invitation to the graduation ceremony. She attends. Sits in the bleachers with other families. Watches Marcus cross the stage in cap and gown. sees his grandmother cry with the particular intensity of someone who knows how close this moment came to not happening. Afterward, Marcus finds her in the crowd. "Ms. Harper, thank you for coming." "Congratulations. What's next?" "University of Illinois. Criminal justice major. Then law school, hopefully." "You'll be good at it." "Because of what I learned watching you. How you fought. How you didn't back down even when they tried to stop you." He pauses. "I'm going to be that kind of lawyer. The kind who doesn't quit." Simone feels something complicated move through her chest. Not pride exactly, but recognition that her fight created possibility for his future in ways that extend beyond case outcomes and statistical reforms. "The system will push back," she tells him. "It always does. But you'll have tools I didn't have when I started. You'll have the Harper Access Act. You'll have precedent. You'll have proof that fighting back can work. Because you showed it could." She doesn't know how to respond to that, so she just nods. They take a photo together, Marcus's family insisting, everyone smiling for the camera while private futures unfold behind their eyes. The award ceremony arrives with the particular energy of formal events designed to make participants feel both honored and uncomfortable. Ballroom at a downtown hotel, 500 attorneys in evening wear, open bar that ensures the networking gets progressively louder as the night advances. Simone attends wearing a dress she bought specifically for this event, navy blue and professional and expensive enough to signal she belongs in this room with these people. Thomas accompanies her, their relationship having settled into something official enough to acknowledge publicly, but private enough that they don't discuss it with colleagues beyond confirming they're together. The Justice and Equality Award comes third in the ceremony, after lifetime achievement and pro bono service recognition. A video plays showing highlights from news coverage of the courthouse access investigation. Her face appears on screen. Testimony clips from the legislative hearing, footage of the press conference. Her name is called. She walks to the stage aware of how many eyes track her movement, how many people in this room know her only through that video, that case, that fight. Not as attorney with dozens of other clients and cases, but as the woman who took on courthouse security and won. The award itself is a crystal plaque mounted on wood base, heavy and expensive, and designed to display on office shelves. Engraved, Illinois State Bar Association Justice and Equality Award, Simone Harper, in recognition of extraordinary dedication to access and equity in the legal system. She's expected to make remarks, keeps them brief. "Thank you for this recognition. But courthouse access reform isn't finished. It's barely started. The Harper Act created framework. Implementation requires constant vigilance. There are attorneys in counties we haven't investigated yet who face the same barriers I documented. There are clients whose cases are compromised by gatekeeping we haven't exposed. This award belongs to them as much as me, the people still fighting battles we haven't won yet." Polite applause. She exits the stage, returns to her seat next to Thomas, who squeezes her hand briefly beneath the table. "Good speech," he murmurs. "True speech." The ceremony continues through 6 more awards. Simone half listens, thinking about the anonymous letter in her files. The 15 counties someone claimed had similar patterns. The scope of investigation required to expose them all. After the ceremony, during the networking reception, 3 different attorneys approach her. 2 black women, 1 Latino man, all with versions of the same story. Detained at courthouse security, credentials questioned, hearings delayed. None filed formal complaints because they didn't think it would matter. All encouraged by her case to consider fighting back. "Your investigation only covered 6 counties, one woman says. But this happens in Cook County too, constantly. We just learned to arrive an hour early because we know we'll be delayed." "Have you documented it?" "Not systematically. We complain to each other, but we don't keep records." Simone pulls out her phone. Opens the database app Thomas helped her create. Start documenting. Date, time, checkpoint location, names if you have them, duration of delay. The more data we collect, the stronger the case for expanding the investigation. She shares the database template with all 3 attorneys. By the end of the night, 12 more people have requested access. The database that started as her personal record-keeping has has become collaborative documentation of systemic barrier. If you're invested in seeing real change happen, subscribe, because this is only the beginning of what organized documentation can accomplish. 8 months later, the expanded investigation encompasses 15 counties, exactly as the anonymous letter promised. 134 attorneys contribute documentation. The pattern holds with mathematical precision. Attorneys of color face extended verification at rates 4 times higher than white colleagues. Delays average 37 minutes versus 9 minutes. Certain attorneys are flagged for additional scrutiny based on their case types rather than security concerns. The second legislative hearing draws more attention than the first. Media coverage, public interest groups, civil rights organizations that see courthouse access as gateway issue, control who gets into the building, control who can effectively practice law, control whose clients receive competent representation. Simone testifies again, but this time she's not alone. 12 other attorneys join her, each sharing their documented experiences, each adding layers to the pattern that transforms individual incidents into systemic evidence. Representative Okafor introduces the expanded Courthouse Access Reform Act. Stronger enforcement mechanisms. Criminal penalties for deliberate retaliation. Federal oversight for counties with documented patterns. The bill passes 8 months later with amendments that weaken some provisions, but preserve the core framework. Progress. Incomplete, compromised, but real. 2 years after her original detention at Checkpoint 3, Simone returns to that courthouse for a client meeting. Approaches the security area with muscle memory of that 97-minute wait still living in her shoulders and her careful breathing. Different guards, new scanners, signposted clearly. Electronic verification required. Manual holds prohibited under Illinois Statute 725 ILCS 185/1. She places her bar card on the scanner. Green light. Beep. 41 seconds from approach to cleared. The guard, young black man, maybe 26 years old, nods respectfully. "Have a good day, counselor." "You too." She takes the elevator to the 5th floor, thinking about the distance between 97 minutes and 41 seconds. The battles fought and laws passed and investigations conducted to transform that gap from personal violation to procedural norm. In the hallway, she passes a younger attorney, white woman maybe 2 years out of law school, who moves through the courthouse with the easy confidence of someone who's never been stopped, who doesn't know the building used to function differently, who benefits from reforms she had no part in fighting. That's the goal, not recognition or awards or her name on legislation, though those came anyway. The goal is making access so routine it becomes invisible. Making the system function correctly, not because heroes forced it to, but because correct functioning is just what the system does. Later that afternoon, Simone meets Thomas for dinner. Their relationship has evolved into partnership, romantic and professional boundaries, blurred in ways that feel sustainable rather than complicated. They share case updates and personal news, and the comfortable silence of people who've built trust through shared work. The anonymous tipster sent another message, Thomas says over appetizers. What now? Federal courts claims the same patterns exist in federal courthouse security, but the Harper Act doesn't apply because it's state legislation. Simone sets down her fork. That's a different jurisdiction, different authority structure, much harder to investigate. But not impossible. She looks at him across the table, reading the question in his expression. Not asking if she wants to take this on, asking if she's ready for another fight when the current one is barely consolidated. "Let me finish the Cook County expansion first," she says. "Then we'll talk about federal courts." Fair enough. They move to other topics, personal plans, weekend possibilities, the normal negotiations of two professionals with demanding careers trying to build something together that isn't just work. But Simone's mind keeps circling back to federal courts, the scope of investigation that would require, the institutional resistance she'd face, the question of whether one person's documentation project can keep expanding, or whether at some point the fight becomes too big for individual effort. 3 months later, she presents at a national conference on courthouse access reform. 200 attorneys from 37 states. Conversations about their own experiences with security gatekeeping, their own documentation efforts, their own frustration with systems that resist accountability. A coalition forms organically over 3 days of workshops and networking. Attorneys committed to expanding the Harper model nationally. Some focus on state legislation. Others target federal regulations. A few tackle private facility security that falls outside courthouse jurisdiction but creates similar barriers. Simone finds herself at the center of something larger than her original fight, not by design but by the gravitational pull of being first. First to document systematically, first to turn personal violation into statistical evidence, first to prove the system could be forced to change. On the final day of the conference, during the closing plenary session, an attorney from Texas approaches the microphone during Q&A. "Ms. Harper, you've become the face of courthouse access reform. But you started as someone who just wanted to reach your hearing on time. How do you balance being a symbol with being a practicing attorney?" Simone considers the question carefully. "I don't think of myself as a symbol. I think of myself as an attorney who documented what happened and used that documentation to fight back. If that inspired other people to do the same, that's good. But the work isn't about me, it's about building systems that don't require extraordinary individual effort to function correctly." "But you did make extraordinary effort." "Because I had no choice. The system failed. I could accept that failure or document it and fight. I chose to fight. But I'd rather live in a world where that fight wasn't necessary, where courthouse security just worked correctly from the beginning." The answer gets applause, but Simone means it literally. She doesn't want to be the person who has to fight these battles. She wants to practice law without that additional burden, wants to focus on her clients without the parallel struggle of reforming systems that should already be fair. But wanting something and having it are different things. So she continues documenting, continues investigating, continues building the case for change, one incident report at a time. 4 years after that first 97-minute detention, Simone receives a letter from Vernon Blake, handwritten, postmarked from Arizona, where he moved after his termination, 6 pages of careful script. The letter is part apology, part justification, part confession. Vernon explains the institutional pressure he faced, the career incentives that rewarded gatekeeping, the subtle encouragement from administrators who wanted problem attorneys slowed down. He describes the coordination network Simone's investigation exposed, filling in details Patricia couldn't provide. "I thought I was protecting courthouse security," Vernon writes. "I believed the narrative that certain attorneys were threats. I didn't question why those threats correlated so perfectly with race and case type. That was cowardice disguised as professionalism." He doesn't ask for forgiveness, doesn't request contact, just provides information he thinks she should have, documentation of system failures from inside perspective. Simone reads the letter twice, files it with other investigation materials, doesn't respond, but doesn't discard it either. It's evidence, like everything else, evidence that systems corrupt the people working within them, that individual choices accumulate into institutional patterns, that change requires addressing both personal accountability and structural incentives. 5 years after the original incident, Simone's practice has evolved. She still handles criminal defense, but increasingly she takes courthouse access cases. Attorneys facing retaliation for their work. Clients whose representation was compromised by barriers their lawyers couldn't overcome. The documentation database she started has become formal practice area with 3 associates who help manage the caseload. She thinks about the student she saw that morning, walking through checkpoint 3 with 41 seconds of smooth processing. Wonders if that student will ever know the courthouse used to function differently. Wonders if invisible reform is the most successful kind, change so complete it erases memory of what came before. Her phone rings. Private number. She answers professionally. "Ms. Harper, this is Judge Harriet Vance. I'm calling to see if you'd be interested in joining the Illinois Judicial Ethics Commission. We need attorneys who understand systemic barriers and aren't afraid to address them." Simone sits in her office, award plaque visible on the shelf behind her desk, database open on her computer screen, case files stacked on every surface. She thinks about the scope of work required to serve on a judicial ethics commission while maintaining her practice and her reform advocacy, and her relationship with Thomas, and some version of personal life that isn't entirely consumed by fighting institutional dysfunction. "Can I have some time to consider it?" she asks. "Of course. Take 2 weeks. Call me when you've decided." They hang up. Simone stares at her computer screen, at the database that's grown from her personal documentation to collaborative record representing hundreds of attorneys and thousands of incidents. The fight that started with 97 minutes at a security checkpoint has expanded into legislative reform and investigation, and now invitation to help shape judicial ethics standards. She doesn't know yet whether she'll accept, doesn't know if she has the energy for one more institutional battle when the existing ones consume so much already. But she has 2 weeks to decide, 2 weeks to weigh the cost against the potential impact, the personal sacrifice against the systemic change. Thomas will tell her to do whatever serves her best, not what serves the movement. Patricia will encourage her to keep pushing while momentum exists. Marcus Wilson, now in law school and already volunteering for legal aid clinics, will see it as inspiration for his own future advocacy work. But the decision is hers alone. Like documentation was hers alone. Like standing in that holding room for 97 minutes was hers alone. Like every choice to fight instead of accepting institutional failure. She opens a new document, starts making a list of pros and cons, begins the same methodical analysis she applies to every decision, weighing evidence and calculating outcomes and building the case for whatever choice she ultimately makes. Outside her office window, Chicago continues its evening routine. Cars passing, people walking home from work, the normal machinery of urban life that continues regardless of courthouse security reforms or legislative victories or individual decisions about how much one person can take on. Somewhere in a different county, an attorney is being detained for longer than necessary. Somewhere else, a client is waiting for their lawyer who's stuck at security. Somewhere else, the patterns continue despite the laws and the investigations and the systemic reforms that haven't reached every corner yet. The work is never finished. The system always finds new ways to resist. But resistance isn't the same as immunity, and documentation, patient and methodical and absolutely relentless, is still the most powerful weapon Simone Harper knows how to wield. She keeps writing, keeps documenting, keeps building the case for a world where courthouse access is just access, routine, invisible, and equally available to everyone regardless of the color of their skin or the nature of their legal work. 2 weeks later, she calls Judge Vance back. "I'll join the commission," she says, "on one condition." "What's that?" "I bring my documentation database with me, make it part of our ethics review process, use real data instead of institutional assumptions." Judge Vance pauses for 3 seconds, then, "Agreed. When can you start?" "First of the month." The call ends. Simone updates her calendar with meeting dates and commission responsibilities. Adds another layer to the work that started with 97 minutes and expanded into movement. She thinks about the anonymous tipster, still sending occasional messages about new counties or federal courts or patterns in attorney discipline proceedings. Wonders who they are, what motivated them to become an insider source, whether they document their own experiences or just observe others and pass along information that might help. Decides it doesn't matter. The information is what matters. The documentation. The patient accumulation of evidence that forces systems to acknowledge what they'd rather ignore. Her phone buzzes. Text from Thomas. "Dinner at 7? Want to celebrate your commission appointment?" She types back, "Yes, but also want to discuss the federal court investigation. Ready to expand." His response, "Always." Simone smiles at the screen, closes her laptop, gathers her briefcase and her coat and her careful habits of documentation that have become both protection and weapon. walks out of her office into the evening thinking about next battles and unfinished reforms, and the long, patient work of changing systems that resist change. The courthouse access fight started with one woman and 97 minutes. 5 years later, it encompasses 15 states, 200 attorneys, 3 pieces of federal legislation under consideration, and a Judicial Ethics Commission appointment that will allow her to institutionalize the reforms she fought for from outside. Not victory, not completion, just progress. Sustained, hard-won, imperfect progress that makes space for the next attorney who won't have to fight the same battles because someone already documented the pattern and forced the system to change. Some fights you win. Some you fight repeatedly until institutional memory shifts and resistance becomes too expensive to maintain. Some you pass to the next generation with better tools and stronger frameworks and proof that challenging power is possible. Simone Harper walks into the Chicago evening thinking about all 3 categories. About the battles she's won, and the ones still fighting, and the ones she'll eventually hand off to attorneys like Marcus Wilson, who are learning from her example how to document, how to resist, how to refuse acceptance of barriers that shouldn't exist. The system will keep pushing back. It always does. But she'll keep documenting. She always does. And somewhere between those 2 certainties lies the slow work of justice, incomplete, exhausting, and absolutely essential. The night is cool, the city is loud, and Simone Harper is patient, meticulous, and relentless when it comes to dismantling barriers one documented violation at a time. Because some victories aren't dramatic, they're just 41 seconds instead of 97 minutes, and that difference, multiplied across thousands of attorneys and millions of court appearances, transforms systems from the inside until one day someone looks around and realizes that the way things work now isn't how they used to work. That change doesn't happen by accident. It happens because someone documented it, fought for it, refused to accept that institutional dysfunction is just how things are. It happens because Simone Harper stood in a holding room for 97 minutes and decided that documentation was power. And power, properly applied with patience and precision, can move even the most resistant systems. The fight continues, the work continues. And somewhere in a courthouse she hasn't investigated yet, an attorney is about to be detained for reasons that have nothing to do with security and everything to do with control. But this time, they have tools. This time, they have precedent. This time, they have proof that fighting back can work. Because someone showed them how. The federal courthouse in downtown Chicago operates under different rules than state facilities. Marble columns that reach 3 stories. Security protocols written in Washington rather than Springfield. Guards who answer to federal marshals rather than county administrators. Simone approaches the main entrance on a Tuesday morning, carrying briefcase and credentials and 5 years of experience that whispers, this will be different. Federal buildings don't bend to state legislation. The Harper Act holds no weight here. She presents her credentials at the checkpoint. Federal attorney registration card, laminated and holographic. The marshal, white man, late 40s, nameplate reading Carson, examines it with the thorough attention of someone actually trained in security rather than just positioned as gatekeeper. Purpose of visit? Oral arguments. Case number 24, CR 3381, United States versus Rodriguez. 9th floor, courtroom 7. Carson scans her card. Green light. Beep. He hands it back. Proceed. 43 seconds. Smooth. Professional. The way it should work. Simone takes the elevator thinking maybe federal courts are different. Maybe the patterns she documented in state facilities don't translate to federal jurisdiction. Maybe this will be easier. The thought lasts until her 3rd visit. Same courthouse. Different marshal at the checkpoint. Young white woman. Nameplate Hendricks, examining Simone's credentials with microscope intensity. This card looks faded. It's 6 months old, normal wear. I'm going to need additional verification. The familiar weight settles in Simone's chest. Not again. Not here. Not when she thought federal professionalism might mean different treatment. The card scanned green, Simone says carefully. What additional verification do you need? Supervisor review, standard protocol for questionable credentials. What makes my credentials questionable? Hendricks doesn't answer. Just radios for her supervisor while Simone checks her watch. Oral arguments start in 19 minutes. She's cutting it close already because of traffic delays and elevator waits. The supervisor arrives. Older man, early 60s, federal marshal insignia on his sleeve. He takes Simone's card without introducing himself, examines it under the scanner light, checks some database on his computer terminal. She's verified, he tells Hendricks. Let her through. 8 minutes. Not 97, but 8 minutes she didn't need to spend proving legitimacy that was already established. 8 minutes that put her arrival at courtroom 7 with 6 minutes to spare instead of the 15 she prefers for final preparation. She documents it anyway. Opens her phone's notes app while walking to the elevator. Date. Time. Checkpoint location. Marshal name. Duration. The habit so ingrained it happens automatically. By her 6th federal court visit, the pattern emerges. 3 checkpoints, 3 different experiences. Once smooth, twice delayed. The ratio better than state courthouses, but still present. Still that friction that correlates with her face rather than her credentials. Simone pulls federal courthouse data through FOIA request. Takes 4 months to arrive, heavily redacted, but enough remains to run analysis. 41 credential verification delays over 6 months. 34 involved attorneys of color. Average duration, 14 minutes versus 5 for white attorneys. Better than state facilities. Still discriminatory. She brings the data to Thomas during dinner at the restaurant they've claimed as theirs. Small Italian place in Lincoln Park, corner booth. Owner who knows their orders by heart. Federal courts, she says, sliding her tablet across the table showing the spreadsheet. Thomas reviews the numbers while his pasta gets cold. His expression shifts from casual to focused, professional mode activating even during personal time. The ratios are better than state level. Still disparate impact under Title VI. Still pattern showing race-based differential treatment. But federal courts have sovereign immunity issues. Much harder to sue. Much harder to enforce reform. I know. Simone retrieves her tablet. That's why I'm considering a different approach. She explains the idea that's been forming during her 3 months on the Illinois Judicial Ethics Commission. Not legislation this time. Federal courts don't answer to state law. Not lawsuit. Sovereign immunity creates barriers. Instead, internal pressure. Documentation submitted to the Administrative Office of the U.S. Courts. Formal complaints to the Circuit Judicial Council. Media attention that forces federal administrators to address patterns they'd prefer to ignore. Thomas listens with the careful attention of someone who's learned when she's asking for feedback versus when she's already decided and just needs tactical support. This will be harder than the state campaign, he says finally. Federal judges are appointed for life. No electoral pressure, no legislative oversight in any meaningful sense. But they care about institutional reputation. Federal courts pride themselves on professionalism. Documented evidence of systematic discrimination undermines that image. So you're betting on embarrassment as enforcement mechanism. I'm betting on data, same as always. Document the pattern until ignoring it becomes more costly than addressing it. Thomas reaches across the table, fingers finding hers. You know I'll support whatever you decide, but I need to ask, are you doing this because it needs to be done, or because you can't stop fighting? The question lands with the particular weight of truth spoken by someone who loves you enough to challenge your motivations. Simone sits with it, examining her own impulses with the same analytical precision she applies to case evidence. Both, she admits. It needs to be done. And yes, I've built my professional identity around these fights in ways that make stopping feel like abandoning people who depend on this work. Those things can both be true. Okay, then let's talk strategy. They spend the rest of dinner planning. Thomas knows federal court administrators through his work on National Bar Association committees, can make introductions, open doors that might stay closed to outside advocates. Simone has the documentation methodology, the database infrastructure, the careful habit of evidence collection. Together, they map the campaign. 6 months of data collection. Recruitment of federal practitioners willing to document their checkpoint experiences. Statistical analysis comparing treatment by race, gender, case type. Formal report submission to the administrative office with media strategy ready if internal channels fail. It's familiar territory. The same pattern that worked for state courthouse reform, adapted to federal jurisdiction. Not revolutionary tactics, just patient systematic documentation of injustice until the evidence becomes undeniable. 3 weeks later, Simone receives an encrypted email. Subject line, Federal Court Patterns, Confidential. She opens it in her office with the door closed and her computer disconnected from network. Standard protocol for sensitive communications from unknown sources. The email contains attachment, spreadsheet with 6 years of federal courthouse checkpoint data, much more comprehensive than what she'd obtained through FOIA. Detailed breakdown by marshal, attorney, case type, demographic categories, the kind of internal data that should be protected by administrative privilege. Someone inside federal court administration is leaking. The accompanying message is brief. Your state court investigation inspired documentation we've been keeping quietly. 14 federal courthouses. Same patterns. Worse in some districts. We can't come forward publicly without losing our positions. But you can use this. Make it count. A friend in federal service. Simone studies the data for 2 hours. The numbers tell story even clearer than state facilities. Systematic delays for attorneys of color. Particular targeting of public defenders and civil rights practitioners. One district shows average verification time of 23 minutes for black attorneys versus 6 minutes for white colleagues. 23 minutes. In federal court. Where professionalism is supposed to be gold standard. She backs up the data to 3 separate encrypted drives. One stays in her office safe. One goes to Thomas. One goes to Lisa Chen at the Bar Association with instructions, if anything happens to me, publish this. The paranoia isn't dramatic. She's learned that people who expose institutional dysfunction face professional retaliation sophisticated enough to seem unrelated to their advocacy. Sudden bar complaints about unrelated cases. IRS audits. Professional reputation attacks that appear coincidental until the pattern becomes visible. Documentation protects. Redundancy protects. Making sure the evidence survives even if the investigator doesn't. This is getting into territory that powerful people want kept quiet. Stay with us to see what happens when federal courts face accountability. The federal court investigation expands quietly for 4 months. Simone recruits 37 attorneys willing to document checkpoint experiences. Public defenders, civil rights practitioners, criminal defense attorneys who handle federal cases regularly. Every demographic category represented to prevent claims that the pattern reflects case type rather than race. The documentation follows strict protocol. Each attorney receives encrypted app for real-time reporting. Date, time, marshal name if visible, duration of delay, reason given if any, demographics of attorneys passing through unchallenged during same period. By month 4, the database contains 217 incidents across 8 federal courthouses in 3 states. The pattern holds with statistical precision. Attorneys of color delayed at 3 times the rate of white colleagues. Average duration disparities ranging from 8 to 23 minutes depending on district. Simone compiles the data into formal report. 83 pages of statistical analysis, incident summaries, legal framework citing Title VI of the Civil Rights Act and federal anti-discrimination regulations. Executive summary designed for administrators who won't read the full report. Appendices with raw data for skeptics who will. She submits it to the administrative office of the U.S. Courts on a Monday morning. Certified mail, return receipt requested, copies to the Circuit Judicial Council and the Federal Judicial Center. Official channels that create paper trail and trigger response obligations. Then she waits. Federal bureaucracy moves with the speed of institutional caution. 6 weeks pass. No response. No acknowledgement beyond the return receipt confirming delivery. Simone drafts media release. Not published yet, just prepared. If official channels fail, she'll take the evidence public. Major news outlets already contacted, ready to run the story when she gives authorization. Week 7 brings response. Letter on administrative office letterhead, signed by the director himself. Dear Ms. Harper, thank you for your report regarding courthouse security procedures. The administrative office takes all allegations of discriminatory treatment seriously. We are conducting internal review of the data you provided and will respond with findings within 90 days. We appreciate your patience during this process. 90 days. 3 months. The bureaucratic holding pattern that often precedes meaningful action, or deliberate burial depending on whether publicity forces accountability. Simone forwards the letter to Thomas with one-line message. 90-day clock starts now. Media strategy activates at day 91 if no substantive response. His reply? Agreed. Already briefing reporters we trust. The next 8 weeks pass in careful waiting. Simone continues her regular practice, client meetings, court appearances, the daily work of criminal defense that pays bills and serves people who need representation regardless of her parallel advocacy work. But she checks email compulsively, monitors news coverage of federal courts, watches for any indication that the administrative office is taking her report seriously versus just running out the clock. Day 73 brings email from unfamiliar address. Subject: We need to talk. In person, private. The sender identifies herself as Rebecca Torres, Senior Policy Analyst at the Administrative Office. Proposes meeting at neutral location, coffee shop in D.C., where Administrative Office headquarters is located. Simone books flight for 3 days later. Tells Thomas she's going alone because some conversations work better without official delegation, without the weight of formal organizational representation. The coffee shop is deliberately generic. Chain location near DuPont Circle. Tourists and professionals mixing in anonymous crowd. Rebecca Torres sits in corner booth, laptop closed, coffee untouched. She's Latina, late 40s, with the careful posture of someone who's navigated federal bureaucracy long enough to know which battles to fight and which to avoid. But her eyes carry something else. Frustration, maybe, or the particular exhaustion of watching problems persist despite internal advocacy. Ms. Harper, thank you for coming. Simone sits across from her, orders coffee she doesn't intend to drink. You've reviewed my report. I've reviewed it. So has my director. So has the Judicial Conference Committee on Court Administration. Your data is compelling. But, Rebecca takes a long breath. But federal courts are decentralized. Each district operates independently. The administrative office provides guidance but cannot mandate security protocols. We can recommend. We can suggest. We cannot enforce. So my report goes nowhere. I didn't say that. Rebecca opens her laptop, turns it so Simone can see the screen. Spreadsheet showing federal districts, security staffing numbers, training requirements, complaint procedures. I've been documenting internal resistance to reform for 3 years. Your report gave me external validation I couldn't generate from inside. She pulls up another file. Draft policy recommendations for federal courthouse security, mandatory bias training, electronic verification requirements, demographic tracking of checkpoint delays. The same reforms Simone fought for in state courts, adapted to federal context. This policy memo has been sitting on my director's desk for 18 months, Rebecca says. He won't sign it because it implies federal courts have discrimination problem, but your external report with independent data creates pressure he can't ignore. What do you need from me? Publicity. Your 90-day deadline expires in 17 days. On day 91, release your findings to media. Make this public in ways that force response. I'll work internal channels simultaneously, coordinate pressure from outside and inside. It's alliance born from shared frustration. Rebecca trapped inside bureaucracy trying to reform it. Simone outside using documentation to force change. Different positions, same goal. How do I know this isn't just administrative office buying more time? Simone asks. You delay my media release, then bury the report anyway? Rebecca meets her eyes. You don't know. You're trusting that I'm who I say I am, someone who's been fighting internal battles and needs external pressure to win them. But you'll release the data either way. I'm just asking you to coordinate timing so internal advocates aren't caught off guard. The calculation is simple. 17 days changes nothing substantive. Either federal courts respond or they don't, but coordinated pressure might be more effective than unilateral media release. Okay, Simone says. 17 days. But if nothing happens on day 91, the full report goes public with documentation of administrative office non-response. Agreed. They spend the next hour coordinating strategy. Rebecca explains internal federal bureaucracy, which committees matter, which administrators hold actual power, which judges on the Judicial Conference might support reform. Simone shares her media contacts, the reporters already briefed and ready to run the story. Partnership between insider and outsider, each providing resources the other lacks. Simone flies back to Chicago thinking about trust and calculated risk and the ways institutional change requires people willing to work both sides of the wall. Rebecca's position inside the administrative office gives her knowledge and access Simone could never obtain. But she lacks Simone's external credibility, her freedom to publicly criticize without career consequences. Together, they might accomplish what neither could alone. Day 89 brings email from the administrative office. Official response to Simone's report, signed by the director with Rebecca Torres copied. The administrative office has completed its review of your report regarding federal courthouse security procedures. We find the data concerning and have initiated the following actions. 1. Mandatory bias training for all federal court security personnel, commencing within 60 days. 2. Implementation of electronic credential verification systems in all federal courthouses, to be completed within 18 months. 3. Quarterly demographic tracking of checkpoint delays, with reports submitted to circuit judicial councils. 4. Establishment of direct complaint line to administrative office for security-related concerns. 5. Policy review of marshal training protocols to emphasize non-discriminatory screening. The letter continues for 3 pages detailing implementation timelines, oversight mechanisms, reporting requirements. Not perfect. 18 months for electronic systems is slower than state reform required. But movement, commitment, institutional acknowledgement that the pattern exists and requires response. Simone forwards the letter to Thomas, to Lisa Chen, to the 37 attorneys who documented their experiences. Subject line: We won. Partial victory, but real. The media releases anyway. Not attack on federal courts for failing to act, but positive coverage of reform commitment. Simone does 3 interviews framing the story as successful collaboration between advocates and institutional leaders. Rebecca Torres is quoted extensively, positioned as internal champion who pushed reform from within. It's true enough. She did push internally. But the coverage doesn't mention that her pushing only succeeded when external pressure made resistance too costly. That's fine. Simone doesn't need credit for the victory, just needs the reforms implemented. 6 months later, the first federal courthouse installs electronic verification scanners. Simone is invited to the ribbon-cutting ceremony. Symbolic gesture that makes good press, but doesn't change the metal and plastic reality of equipment that will process credentials without human bias. She attends anyway, stands with Rebecca Torres and federal judges and court administrators who praise the administrative office's forward-thinking commitment to equity and access. The irony of receiving praise for forcing them to do what should have been standard practice isn't lost on her. But she smiles for cameras and gives brief remarks about the importance of equal access and thanks the administrative office for their leadership, politics, the necessary theater that accompanies institutional change. After the ceremony, Rebecca pulls her aside. "Thank you for making me look good in there. You did the internal work. You deserve credit. We both know I couldn't move this without your external pressure, but I appreciate the public positioning." Rebecca pauses. There's something else. Another pattern. Involves federal judges themselves. Simone's attention sharpens. "Explain." "Recusal practices. Federal judges are supposed to recuse from cases where they have conflicts of interest, but there's no enforcement mechanism, no oversight. It's entirely self-policing. And the data suggests—" She trails off, looking around the marble hallway where other ceremony attendees mill about. "Not here," Simone says. "Send me encrypted email with whatever you have. I'll review it." They exchange contact information under the pretense of coordinating future reform efforts. Anyone watching sees two professionals networking at an institutional event. No one sees the beginning of the next investigation, the next pattern waiting to be documented and exposed, because the work is never finished. Fix courthouse security, discover judicial recusal problems. Address recusal, find demographic disparities in sentencing. Reform sentencing, uncover bail inequities. Each victory reveals the next battle because systems of injustice aren't isolated problems. They're interconnected web of practices that protect power and resist accountability. Simone has learned to pace herself. Can't fight every battle simultaneously. Has to choose which patterns to pursue and which to document for future advocates to address. But she also knows that documentation never stops. Every interaction, every incident, every moment when the system fails to function fairly, all of it gets recorded. Because today's observation becomes tomorrow's evidence. Today's anomaly becomes tomorrow's pattern. Today's personal experience becomes tomorrow's systematic reform. The ribbon-cutting ceremony concludes. Guests disperse. Simone takes a car to the airport for her evening flight back to Chicago, thinking about Rebecca's cryptic comment about judicial recusal. Wondering what data she'll receive, what pattern it will reveal, whether she has energy for another multi-year investigation. Her phone buzzes. Text from Marcus Wilson, now finishing his second year of law school. "Ms. Harper, just got summer internship with Legal Aid, Federal Defender Division, following your path." She types back, "Congratulations, you'll be great. Remember what I taught you about documentation?" His response, "Always. Every interaction, every detail. Build the record." Simone smiles. The work continues not just through her own efforts, but through the students and young attorneys who learned from her example, who carry forward the habits of systematic documentation, who understand that individual acts of resistance accumulate into institutional change. That's how systems transform. Not through heroes, but through distributed effort. Not through dramatic confrontations, but through patient accumulation of evidence. Not through single victories, but through sustained pressure that makes resistance more costly than reform. The plane takes off. Chicago appears in the window, city lights spreading across dark landscape. Somewhere down there, attorneys are passing through courthouse security, some smoothly, some facing friction. Each experience potentially becoming data point in the next investigation, the next pattern, the next reform. Simone opens her laptop, begins drafting framework for analyzing judicial recusal data, even though she hasn't received Rebecca's information yet. Preparation, anticipation, the constant forward motion of someone who learned that stopping means accepting injustice, and acceptance has never been an option. The fight continues. The documentation continues. And somewhere between those two certainties lies the patient work of justice, incomplete, exhausting, essential, and absolutely worth the cost.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.